Listen, I want to explain something too before we start the meeting. Outbursts will not be tolerated. We're all here for a purpose. We want everybody heard tonight. So we want to do this the right way, get everybody's testimony that we can tonight, and get it all. But if there's any outbursts in here, you'll be escorted off the property. We're trying to hold this to get a procedure through. We're happy all of y'all are here. We want you heard. But doing outbursts is not the way to do it. So let's at least be professional and courteous, have some courtesy in here and respect for individuals. We have a job to do, just like you have jobs, most of you, or if you're unless you're retired and you still got a job. But we want to get through this tonight. We want to hear everybody and for everybody to be heard and the facts to be put into evidence so this board can hear all of it. And if it's going to be disrupted, then that hurts the process. So I ask you respectfully to respect everybody here and respect my staff and my board. So if we can do that, we can get the meeting started. We had a problem. Our town attorney had an issue. It took a little while for him to get here. But he's here, and Ms. Norwood, I guess you're ready to go.
Yeah. Oh my God, I'm sorry.
So we'll go ahead, if everybody's ready, we'll go ahead and get this process started so we can hear everybody, and we want to hear everybody tonight. I'd like to call to order the Belville Board of Commissioners, a special meeting, January 6, 2022, at actually 6 p.m. It's actually 6:25 right now. If we could, we'd stand the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank y'all so much.
Mr. Mayor, you want me to go over the ground rules before we get started here?
Let me go ahead and excuse our commissioner, sir. Let me get very preliminary out, and then we'll go over that. One of our commissioners, Commissioner Long, cannot be here tonight because of COVID. So if I could I have a motion that we excuse him for tonight's meeting?
Motion to excuse.
All in favor?
Aye.
All opposed? The ayes have it. Thank you for that. Also, the approval of the agenda. If the commissioners had an opportunity to look through the agenda for tonight, if there's no issues or concerns, can I have a motion that we accept the agenda?
Motion to accept the agenda.
All in favor?
Aye.
All opposed? The ayes have it. Thank you. Ms. Town Attorney, you want to make some comments?
Yes. Folks, we're here, as the mayor pointed out a moment ago, for a quasi-judicial hearing. This is a little bit different from the typical public hearing where people just stand up and essentially vent about how they feel about a project. The applicant here, and some of you may have been here for the planning board version of this earlier, the applicant has applied for a special use permit. They have a set of showings that they have to make for that, a list of conditions, and they present evidence. Very similar to what would happen if you were in court presenting evidence in a court proceeding. Now, there are some general rules about public hearings in general that North Carolina has. It's in 168-81, and then for conditional use or quasi-judicial hearings like we're in, and those are in 160D-406. But generally speaking, to save time in one of these, the board is allowed to impose conditions on the type of presentation and not allow, for example, repetitive evidence. And just to give you an example about something that frequently comes up, traffic. And I'm going to talk about that because there are three types of evidence that only expert witnesses are allowed to give testimony on. One of them is impact on traffic, another one is impact on property values, and the third one's kind of a catch-all, and that's any other thing that would ordinarily be the subject of expert testimony in court. To give you a great example of that, drainage often comes up. Those are one of those things that ordinarily you need a civil engineer to talk about. So, to go back to that thing about traffic, and those conditions, by the way, come from the General Assembly. They have determined that only experts get to testify about those. In the interest of saving time in one of these, if assuming that you have competent evidence to stand up and testify about traffic or property values, repetitive evidence is something that is not helpful for the board. These folks are essentially volunteers, the town board members. So being here until midnight really isn't their interest, and it's not helpful for anyone. You get tired, you can't really accept any more evidence. So we'd ask that you not offer repetitive comments on things that somebody else has already plowed 5 or 6 or 7 times. It's not helpful for anyone. The other thing is, as the mayor pointed out, we're expecting and requiring some level of decorum here. Don't shout, don't stand up, don't holler. No need for clapping. You don't do that in court. If you go to testify in traffic court, you don't have people clapping and cheering. You don't need that here either. Okay? So the other thing about it is, this is testimony, this is evidence that's being given. As the mayor pointed out, this is quasi-judicial, a quasi-judicial hearing. The testimony that we'll be taking is sworn testimony for the most part. There are some other things that come into evidence, the staff report, some other types of evidence that can be offered, but it's somewhat limited. Also, the people who stand up, not the applicant, but anyone who opposes the application, the general statutes tell us that they have to have what's called standing. They have to have somebody who has a real interest in the matter. So, to give you an example of what standing means, just because you live on the other side of town and drive by a project, in Wilmington we've had a lot of complaints about the number of car washes and self-storage places. Okay? You don't have standing just because you live in Wilmington and you think that there are too many car washes and self-storage places. On the other hand, if you live right next door to where a proposed car wash or self-storage place is coming in and you've got a residence and you can point to some specific way that it may harm your property, different from the rest of the public in general, you might have standing. You're likely to even. So that's kind of the dividing line. Okay, when you stand up, if you are going to stand up and testify, if you're going to oppose this thing, you need to identify yourself, tell us where your property is located, and that will give us the opportunity to determine whether or not you likely have standing in this. If you don't, you're not going to be allowed to testify because your testimony is not helpful and not useful in this situation, and the board shouldn't consider it. So those are some of the ground rules on this. We're trying to work through this in a coherent fashion. I apologize. I was a little late here tonight. I was gathering materials so I can try to help get this thing moved along as quick as we can on this as far as the evidence presented goes, because we're hoping that we won't be here forever on this tonight. And that we can keep the record clean in case anybody else has any questions about it going forward. The applicant, and in this case staff, will go first, and then the applicant. And then anyone else who wishes to be a party to the matter, we'll get to you after that. The people who have standing, once they get up and establish that, you do have a right to question witnesses, and that runs both ways. If a party opposes this and the applicant wants to question them, they'll be allowed to question them. Same thing with people who have standing who want to contest it. they'll be allowed to to ask questions of the applicant, or the applicant's witnesses. So that's kind of the ground rules on this. Again, the board, they're dealing with somebody's property here, just like any of those, and I'm going to go ahead and tell you, any of you have standing here, you're essentially going to be limited to a property owner who's close by. These people are property owners, the applicants, just like the other folks who come here, I assume, to contest this, and those, they have rights too. It's their property. The law favors free use of property in general. So what zoning codes do is they impose reasonable restrictions on it. This is a special use here. It is allowed in this district, in this zoning district. It's business residential district. So we're just trying to figure out whether this particular special use is appropriate on this lot or not. And that's the question for the board. We're going to be focusing on that. I'm sorry if I've gone through this before and all of you have heard it before, but it is important for those of you who haven't to know that, and it'll help us focus on what the real issues here. It's not about how somebody feels about things, it's about what the evidence is for the board. So I want you to know that we're not going to stand up and take a show of hands in this. This is not a democratic process, okay? It's an evidentiary process. They're treated like a court. So it doesn't matter if almost everybody, if it's 99-1 against it in the crowd, it doesn't matter. The question is whether or not the applicant has met these standards. Now, I want to give you one caveat to that. Once the applicant presents evidence that each one of the conditions is met, they are entitled to the permit. And that's a very important thing. It is, after all, their property. If they can offer evidence that they've met the conditions, the presumption is that they get the permit. The board can impose reasonable conditions on it. If there's conflicting evidence on something, the board can consider that. But all the applicant has to do is show some evidence that they've met all the conditions, and then they are presumptively entitled to it. So that a lot of people, I think, don't like the way the law works on that, but after all, it is their property. If you were a property owner, and again, any of you with standing, you're going to be a property owner, you don't want other people dictating to you how you use your property. So that's the situation that we're in right here. We're going to get started on this, and remember, even if you disagree with people, at least be courteous. Keep your thoughts to yourself on that until you're recognized by the chair on this. Mr. Mayor, is there anything else?
Thank you, sir. The only thing I'm going to be repetitive just for one little short paragraph, because I want to understand the statutes we come from. North Carolina General Statute 160D-406 is a general statute that covers quasi-judicial procedures. During a quasi-judicial hearing, the hearing body must hold an evidentiary hearing and make its decision based on the written and oral evidence presented. Unlike legislative decisions like zoning, quasi-judicial must be based solely on the evidence presented and cannot be based on opinions of members of the hearing body. But differently, a quasi-judicial decision is one that requires the hearing body to find facts and exercise discretion when applying the standards of an ordinance to specific situations. And the ordinance we're looking at in our town is Article 9 of our ordinance. I just wanted that on the record as we proceed. At this time, if I could I have the town staff that are testifying to please come up and stand so I can swear you in. Everybody raise your right hand. I solemnly swear to tell the whole truth and nothing but the truth, so help me God, or affirm.
I do.
Thank you. Okay, the next group will be the applicant that's applying for the special use permit. If you could come before the town clerk, she will swear you in.
I do solemnly swear to tell the whole truth and nothing but the truth, so help me God.
If anyone has factual evidence to give on the opposition side, you need to come forward and be sworn in.
Raise your right hand. I swear that I will support and nothing but the truth, so help me God. Everybody went. That was one minute, you can listen to it.
Let's turn to any issues.
No, just a question about conflicts of interest.
Okay, if we could this time, if the town manager or staff has any pertinent testimony to give, please come forward.
Thank you, Mr. Mayor. This is an application for a special use permit filed by Evolve at Waterford Village LLC. The property is vacant land located along Pool Road.
I can turn this.
Properties surrounding are zoned residential, business highway, industrial, and commercial. Residential properties also within the town of Leland. Evolve is requesting that the town approve a special use permit to allow new residential construction along Pool Road. And the property is zoned business residential with approximately 502,000 square feet, 408 units, and also amenities included, such as a pool, pickleball court, fitness building, and garages. All necessary driveway permits will be obtained by the North Carolina Department of Transportation or from them. The site doesn't contain any known wetlands at this time. The staff requests that you review the planning board's recommendation along with any relevant evidence. And I'm going to turn it over to Mr. Capadona.
Sure. So I just wanted to bring a few things to your attention, so everybody can hear me. So I believe you all have plan sets on your desks. That'll help me go through these comments. For one, I just want to bring to your attention that not only does this project contain properties within the town of Belville, there is a small parcel that shows on sheet C2-1 of the plan set. It's the third sheet in. That's what I call the skinny parcel. It's within the town of Leland. It's a little bit unique to this project. Just want to bring that to your attention. Also regarding trees, that would be the last sheet in the plan set and the second to last sheet in the plan set. There are several protected trees proposed to be removed in this project. All of the protected trees meet the requirements of the ordinance, and I just want to read from the ordinance so it's clear where that requirement is coming from. From section 10.5.3 of the ordinance, protected trees are to be retained and protected to the maximum extent feasible. No permit shall be issued for the removal of protected trees unless one of the following conditions exists. This project falls into subsection B, which addresses necessity to remove trees in order to construct proposed improvements as a result of need for access to the building site for construction equipment, also location of proposed structure, and location of proposed parking spaces and associated circulation required to be installed by the zoning ordinance. All that being said, the protected trees proposed to be removed fall into those categories. They're either located where there's a proposed building or proposed parking, etc. I've made the point at the planning board meeting that it could be interpreted that the developer could change the design and move buildings to protect as many trees. But given the layout of the development, all of the protected trees that are shown to be removed fall into those categories from the ordinance, so they are allowed to be removed. Next comment would be parking. This one was extensively discussed at the planning board meeting. On sheet C20, there's a table on the bottom left that shows the parking requirements and proposed parking. The ordinance for this type of project calculates the required parking as 816 spaces. The proposed parking is 752 spaces, which is less than what the required parking would be. The required parking comes from the requirement for 2 spaces per unit. And the proposed parking will be 1.84 spaces per unit. So there was a good bit of discussion at the planning board meeting about that. I believe I made the point that Wilmington, I believe at least in some cases, uses, instead of 2 spaces per unit, they'll go 1.5 spaces per unit, which in that case, this project would meet that particular requirement. So that may need to be further discussed in terms of parking, so I'll leave that one at that for now. Then regarding I had a few comments on the updated plans that the town recently received, particularly with respect to the conditions that the planning board had drafted, proposed or recommended conditions for this special use permit. Most of them were somewhat minor. The one I do want to talk about is the buffering and fencing. One of the recommended conditions was that the applicant would install a privacy fence 6 feet tall, extending to the end of the berm on the north side of the property. So essentially filling in where there's no berm currently existing, filling in with a 6-foot privacy fence. And the condition also included a vegetative buffer to be installed as required by town staff to create buffer between applicant's property and adjoining homeowners. So the fencing has been included. The buffer that has been shown on the updated plans is shown as 10 feet wide, approximately. It's not specifically called out. So the point I want to make is, as it was discussed at the planning board, the buffer requirements for this project, there's not a ordinance requirement for the buffer to be in place between this northern edge of the property and the Leland properties. It would, a project of this type would require a buffer if it bordered R10 or R15 zoning district properties within the town of Belville. But this bordering the town of Leland, it's not an R10 or R15 property, so it's difficult to apply that ordinance in this case. That being said, in the cases where that buffer is required, it's required to be 20 feet wide, and the ordinance also requires things as such as opacity and height, etc. So it may be worth adding to the conditions those specific requirements that the ordinance requires, and maybe considering something other than the 10 feet that was shown on the updated plans. A couple other things. Might seem like a minor comment, but bicycle parking was discussed with the planning board. It was condition number 5 in this list. Applicant shall include bicycle parking as required by the town zoning ordinance. The bicycle parking was shown in the updated plans. The line work was shown, but it wasn't specifically called out. I would recommend maybe just easiest thing to do is to include in the condition for this project the specific number of spaces, bicycle spaces that are required. And long story short, for this project, it would be 66 bicycle spaces based on the town's ordinance. Also, condition number 6 from that planning board meeting was that the applicant shall supply an architectural rendering to staff to ensure compliance with the ordinance. I have not seen that rendering. I don't know if it was supplied or not, but that would be needed to ensure compliance with the ordinance.
It was.
And related to that, that's also going to confirm building height. Here we go. So yeah, I will confirm that they're meeting maximum building height requirements, which we expected them to do. So I can take a closer look at this plan and confirm that that is the case. With that, that's all of my comments.
Okay, thank you, sir. Any questions from the board?
Mr. Mayor?
Yes.
If I may add, the staff report for tonight and agenda packet will be entered into the record as Exhibit A. The application that the applicant submitted, the site plan, and the updated plans as Exhibit B. Engineer's comments and his other items are added in as Exhibit C, and all prior evidence from the hearing would be Exhibit D, from the previous hearing.
And I'll read the form statement, correct?
Yes.
Okay, any other comments, testimony from the staff?
Okay.
Okay, at this time, if there's no question from the board, we'll move on to the applicant. If the applicant would like to offer testimony, please come forward at this time.
Good evening, Mr. Mayor and Commissioners. My name is Jerry Vannon. I'm an attorney, and I'm here on behalf of the applicant. And I'd just like to make a few opening statements, if I may, which I think will be beneficial to the board as we move forward with the hearing on the application.
Can you pull that mic forward just a little bit, sir?
Is that better? No. Hello?
Get the mic on. Get the mic on.
You just have to talk closer. Fortunately, we need to work on our audio systems.
Okay, how about that?
Yeah.
Okay. You're welcome. So that the applicant filed an application for a special use permit with the town on November 17th of 2021. Together with the application, there was a major site plan application and accompanying documents. Staff analyzed the application and thereafter recommended to the planning board that the proposed special use permit application satisfies all findings and complies with the Belville Vision 2030 plan, and recommended approval of the application. That, as everybody knows, that and most of the people were present, I expect everybody was here, was also at the November 30th hearing, that we had a quasi-judicial hearing in front of the planning board, as I stated, on November 30th. The applicant appeared at the hearing and presented competent material and substantial evidence in support of the 9 findings required for the issuance of a special use permit. That at the hearing, we heard evidence from Mr. Brad Schuler from Paramount, who's a certified land planner, and Mr. Schuler principally testified to the meeting of all the required findings for the special use permit. In addition to Mr. Schuler, we had Ms. Elise Rocks, who is she's a certified real estate appraiser. That Ms. Rocks testified that, in her opinion, that the impact of the value on adjoining properties was going to be neutral. That we also had Carolyn Cheeves testify. Ms. Cheeves is an engineer with Ramey Kemp, and she performed a traffic analysis, and she made findings that the development as proposed was not going to negatively impact traffic. And from there, that the planning board, eventually found in favor of granting the application for the special use permit for the applicant with several conditions. That the applicant agreed to the conditions, and the applicant has filed, as staff noted, some amended plans and materials to specifically address the recommendations and conditions of the planning board. That also, I'd like to point out and bring to light that at the November 30th hearing, as staff commented, there was significant comment with regard to parking. Now, since the application was turned in early November, that this board has actually amended its ordinances with regard to parking. And the Article 9, and specifically 9.2, now allows this board to make minor adjustments to the parking requirements. And the minor adjustments being, in this particular instance, an adjustment up to 15%. That you'll hear testimony later from Mr. Schuler that what the applicant is proposing is roughly an 8% variance, which is well within the threshold in your discretion to grant. And I would like to make sure that as part of this evidentiary hearing, that you also consider our request officially pursuant to the Article 9 as amended with regard to the minor variance, for the parking.
Variance is part of this hearing.
Yes.
Yes.
Thank you, sir.
And Mr. Mayor, if it helps, that one of the revisions to Chapter 160D,
Correct.
applicants are allowed to use either the last version or this version. They get to pick and choose nowadays among which code provisions. So that's entirely permissible for them to ask for something that was added subsequent to their application.
Yeah. I saw it in the information that we had in our packets on the entire board's.
And lastly, before I turn things over, I believe staff, part of the evidentiary package is the sworn testimony of the applicant and the exhibits from the applicant, plus the sworn cross-examination testimony of the applicant is part of this record. I just want to make sure that that is admitted and is part of this record. And with that, we'll like to call our first witness, and that would be Mr. Brad Schuler.
Thank you, sir.
Mr. Mayor, at this point, if you'd like, and Mr. Manning, if you'd like, it may save time if you have all the folks that you anticipate testifying be sworn at once. I thought it was just the other folks that were sworn. I didn't realize it was.
Thank you, Mr. Mayor, members of the board. My name is Brad Schuler. I'm the planner with Paramount Engineering. As you know, we're here tonight to seek approval of our special use permit application in order to construct a multi-family development. Next slide, please, Sharon. So shown here is a map of the area highlighted in red as the subject site. As you can see, it's located on Pool Road, which connects to Old Waterford Way, which is adjacent to the Harris Teeter Shopping Center. Next slide. As mentioned, the site is zoned business residential, which permits a mixture of commercial and residential uses. This property was zoned to this zoning district within the last year, and while this district permits a mixture of both residential and commercial uses, it does not require a mixture of uses within a single development. Multifamily residential is permitted in this zoning district with the issuance of a special use permit. So as you can see on the map, industrial zoning and development is currently located directly south of the property. Commercial development is located to the east within the town of Leland, and the Waterford community is located to the north and is also within the town of Leland. The portion of Waterford adjacent the subject site is zoned as Leland's R6 zoning district, which the town identifies as a medium density district. Next slide, please. As staff went over, this was considered by the planning board in November, and they recommended approval of it with conditions that are listed here. So these conditions include limiting the exterior lighting along the abutting housing, relocating a pickleball court and dumpster away from the existing housing, and that a buffer yard be installed on the eastern portion of the property consisting of a privacy fence and some vegetation. In addition, bicycle parking will need to be provided in the development, and we will have to obtain, obviously, all of our state and town stormwater permits and provide those to staff, and provide the architectural rendering to staff, which we have done. Next slide, please. So shown here is the updated site plan that reflects the planning board's conditions. Again, we are proposing a multifamily development consisting of 408 units. This number is far below what could be allowed under the business residential district. Specifically, this district would allow up to 745 units on the subject site. Again, we're only proposing 408 units. This slide here is showing the western portion of the site. On this side of the property, there's an existing vegetated berm that's approximately 8 to 9 feet tall in height and runs along the northern property line. Bicycle parking has been provided throughout the site as well. There's the little typical on there. I believe we did some miscalculations, so Jeff will have to provide some additional bicycle parking, but we can easily get that updated on the plan. I believe we have 30 spaces that are shown currently, and we can add double that easily on there. So thank you for pointing that out, Jeff. Next slide, please. Shown here, so this is the eastern portion of the site. So the existing berm does not continue along this portion of the property, and therefore the planning board added a condition that a buffer be installed along the northern property line. Again, that buffer will consist of a 6-foot tall privacy fence and 2 rows of vegetation. This is consistent with what's required in the town buffer yard. I know the width is a little different, but what actually gets installed within the buffer yard with a 6-foot privacy fence and 2 rows of vegetation, that is what would be required if the subject site was zoned R10 or if the neighboring site was zoned R10 or R15. The dumpster and the pickleball court, as you can see, have been relocated away from the housing closer to the southern portion of the property. And again, we do have some bicycle parking provided as well. As mentioned, we are proposing a reduction in the parking for the development. As discussed earlier, the town requires 2 parking spaces per unit. Evolve Companies, who is the company that will be building the proposed development, has constructed several multifamily developments all over southeastern United States, and they have found that they do not need to provide that much parking in order to serve the residents of their community. And one thing is they want to ensure that there is efficient parking. One thing they don't want is there to be an issue with parking in their communities. And so they have found that 2 parking spaces per unit is overparked. And so by seeking this reduction, we are actually reducing the amount of impervious surface on the site and increasing the green area. This project specifically has about 10 acres of open space, which includes the clubhouse, the fitness center, the stormwater pond, but you got about 40% of the site that's within open space areas. Also, some reasoning for the parking reduction is that multifamily developments include a percentage of 1-bedroom units, and the parking area is shared amongst the residents, unlike with single-family housing, where only the family residing in that home is going to use the driveway in front of their house. In this case, everybody can use the parking that's available. Again, the planning board thought this was appropriate to allow for the reduction, and they agreed and recommended approval of the project with the parking reduction. As stated, we understand that this board has the discretion to approve a reduction up to 15%. We're asking for an 8% reduction. Next slide, please. So overall, we believe this development will provide an appropriate transition between existing housing to the north and between the existing housing to the north and the industrial development to the south, excuse me. Would also continue to promote a mix of uses in this area. This part of the town, again, it already has commercial, industrial, and residential uses. So this will just add another housing type to the area, add to the mixture of uses. Obviously, the benefits of a mixed-use development is that you're going to put folks closer to the daily services that they need. This proposal will do just that. Again, they're in a short distance to the adjacent Harris Teeter Shopping Center and with a bunch of shops and restaurants, etc. Next slide, please. As mentioned, we have to provide some testimony relating to the 9 findings of fact needed in order to approve the SUP. Next slide, please. I'll go into some more detail on them. These are based strongly on what the planning board found and based on their order. But one is that the use will not materially endanger the public health or safety. As noted with the planning board, it will not materially endanger the public. The applicant has experience with developing multifamily developments, and there's been no adverse impacts observed at other properties with a similar design. The special use permit meets all the required conditions and specifications. Again, this is a use that is permitted in the zoning district with a special use permit. And again, the Board of Commissioners have the authority to approve the parking reduction. Next slide, please. The use will not substantially injure the value of adjoining or abutting properties. I'm going to reserve that testimony for our Elise Rocks, our appraiser. The fourth finding is that the use will be harmonious with the area, general conformity with a comprehensive plan. Again, the area consists of a mixture of commercial and industrial uses, also but some single family, and it will be an appropriate transition between that industrial development and the single family housing. And then also the conditions that were added to the development from the planning board will help mitigate any impacts that the proposed multifamily have on the adjacent housing. Next slide, please. The special use will not be injurious to the permitted uses and enjoyment of the other properties in the vicinity. Again, and I think that the town attorney will agree a lot of these findings overlap a little. But again, there's a mixture of uses already in the area. There's a proposed multifamily development will be an appropriate transition, and with the added conditions, it will help mitigate any impacts the proposal will have on the adjacent single-family housing. The special use permit will not be injurious to permitted uses in the enjoyment of other properties in the vicinity. Again, this will be a appropriate transition of uses between the industrial and the single-family. Next slide, please. As for the architecture finding, I want to be clear when I read this. The exact finding is the exterior architectural appeal and functional plan of any proposed special use structure will not be significantly inconsistent with the exterior architectural appeal and function of structures already constructed or being constructed in the vicinity of the subject property. Again, there's a lot of different building types in this area since it does have a mixture of uses. The property directly south the industrial property directly south of the site includes large-scale metal buildings. This is going to be an improvement to the area than the what's in the industrial development to the south. The apartment complex is going to be a residential development. It's going to have open space areas. It's going to have landscape areas. It's going to have recreation areas. What we are proposing here is a residential development. The applicant has experience in developing these projects, and the proposed project will have similar architectural features of the recent projects they have developed, and again, it will offer an appropriate transition by providing a residentially designed building between the existing housing and the adjacent industrial development. Next slide, please. Again, as far as adequate utilities, access roads, drainage, etc., we have to get all of our state and local permits before we can develop the site. We will get all of those, all the stormwater permits, etc. And again, we will meet the town's requirements. We're asking for the parking reduction. And then adequate measures have been taken to provide ingress and egress designs to minimize traffic congestion. I'm going to let our traffic engineer provide some information for you. He has done a traffic study that will show that we are meeting that standard. Lastly, I just wanted to go over, understand the Waterford HOA provided a letter to this board. I just wanted to take a couple moments to address some of the comments made in that. As far as the lack of adequate notice, it was noted that this is meeting the town's notice standards and the state statutes for notice in 160D. As far as the purpose statement of the business residential zoning district, that's technically not a zoning requirement, that is a purpose statement, but we feel like it actually is meeting the intent of the statement. Specifically in that purpose statement, it says it is not the intent to require each separate building or every individual development site to include a complete integrated mix of land uses, but rather for the area as a whole to contain a mix of uses designed to meet the town's overall planning objectives. And that's exactly what we're doing here with this proposal, by adding a new housing type to the area that is just increasing the mix of uses that are in this area. As far as the parking, we went over that several times. I'll skip that one. As far as the turn lane requirement, it's our understanding, what staff has determined and what's written in the code is that is a standard that is determined by the zoning code administrator. They obviously had not required a turn lane to be installed, so we are meeting that section of the code. As it comes to wetlands, all the environmental analysis that we have done on the property show there are no wetlands on the site. Therefore, there are none shown on the site plan. We're still in the early stages. We understand we still have to do a lot more engineering to build this. We will continue to analyze the site and provide any additional wetland documentation that's required by any state or local agency. But what we have done to this date shows there's no wetlands on the property. The tree protection plan, as Jeff went over, we do show the existing trees on the site and which ones will need to be removed. We understand we're going to have to mitigate those trees. There's going to be a lot more trees that are going to have to be planted on the site as a result of that mitigation, but we are fully aware that we're going to have to submit additional documentation to staff for review and approval before we're able to remove any trees on the site. We got to get through some more engineering plans to determine exactly what trees need to come down, but we understand that we will have to mitigate those, and we're fully prepared to do so. And then as for the TIA, again, that's up to the discretion of staff. One was not required. We actually do have a traffic study though, and so our traffic engineer will present that to you. And then as far as the skinny parcel being within the town of Leland, we understand we're going to have to go to the town of Leland and go through their permitting process. We're only proposing a small driveway connection through that parcel. That parcel was dedicated before, I think, Waterford as a right-of-way. It was always the intention that that was going to be a roadway at some point. Waterford amended the plans, did not make a connection to that area, but it's always been the intention of that parcel to be a roadway. And we will work with the town of Leland and go through their permitting process in order to get the approval to do that. We haven't done that at this point. We're waiting to get the approval of this board first before we work on those plans and work with the town of Leland. But we understand that there's no zoning regulations from the town that would prevent that connection from going in and getting installed. And with that, that concludes my presentation.
Board members, y'all have any questions? As the opposition, if you don't mind, sir, just a minute.
Mr. Chair, before we turn him over to the, for cross-examination, can I take care of just a couple of evidentiary issues?
Yes, sir. Come on forward.
Okay, you can just, Brad, you can just stay right there. I'm just asking you a few questions.
It's not.
Brad, can you, I'm not getting testimony.
He's not testifying.
Could you tell us a little bit about yourself, tell the board about yourself, your qualifications, where you're employed, degrees?
Yes. Again, I
Hold on a minute. Listen now, we said that we'd be professional and courteous to people as they testify. When you get your opportunity to come up here, you want to be shown the same relevance and you want people to hear you. So please let the people testify and let's get through this in a professional and courteous manner. Thank you.
For what it's worth, folks, Mr. Mann, I assume, is trying to establish that he's competent to offer technical testimony on some of these things. So that's, go ahead.
Go ahead, sir.
Thank you, Mr. Mayor. Again, I am currently employed as a planner with Paramount Engineering. I have been a professional planner for about 13 years now. I have a degree in urban and regional planning from East Carolina University. I have, prior to working at Paramount Engineering, I have worked for 3 local governments as a planner, most recently as the senior current planner for New Hanover County.
Okay,
Mr. Chair, I'd like to tender him as an
Go ahead,
expert
sir.
in land planning.
say that again, sir.
I'd like to tender him as an expert in land planning.
Okay. Anything else?
No, sir.
If not, if we could have you hold just a minute. Does anybody in the opposition have a question about the evidence that he just gave? Yes, sir. Identify yourself.
You're gonna need to stand up and explain
Kurt
what your
Nielsen.
standing is on
Yeah.
this.
Kurt Nielsen, I live at 1046 Garden Club Way in Waterford. So my backyard and back fence abut the property directly. So I attended the November planning board meeting, and I believe, unless I missed something, that there was discussion about trees going up, because I've got a 6-foot fence and you're gonna have a 3-story apartment. So I believe there was discussion about, and the planning commission board imposed that there'd be 20-foot trees along that area on the north side, but I didn't see anything in your presentation.
So the official planning board condition just noted that the landscaping needs to be determined by staff. So there was no exact, and that's what I didn't write the condition, but that was the official condition that was provided to us. We are proposing, again, a 6-foot solid wood fence and 2 rows of vegetation there. We will submit that to staff and have them make the determination as to if any additional vegetation or the type of vegetation needs to change.
So I guess I'm confused, because I thought there was, so when you're saying that staff has to do, is that the planning staff or the commission?
Objection, Your Honor. That
Yes.
the planning board's order, findings, and recommendations that's been entered into evidence speaks for itself. I mean, that's what was recommended.
Okay. I guess can you rephrase, if you have a question that's actually, just ask it in a question form of what you
Okay.
want him to answer. And it's
All
gonna be
right.
yes or no if there's
So were you at the planning commission board in November?
Yes.
Do you recall discussion about 20-foot trees being along the north side?
I recall that was a suggestion, but ultimately that's not what the planning board recommended.
Okay, sir. Okay, has anybody else got a question? If you do, please stand and identify yourself and ask your question.
Hi, Carol Huber, 1036 Golden Sands Way. Mask and glasses.
The clerk is gonna have to get this down, so you need to speak up and,
Carol Huber, 1036 Golden Sands Way, Wheeling. Going along with that gentleman's question, I do recall hearing the 20-foot trees. I also do recall the woman that was over here when it was expressed that the town expert would pick out the plants, the type of trees, not necessarily the size. The size was
Objection,
decided.
Mr. Mayor. If she's got a
Excuse me, I
question,
didn't finish
if
speaking.
she's got a question, let
Okay,
her, let her
sir,
ask the
ma'am,
question.
what he's trying to say is, in this type here, you got to be direct with your question.
Okay,
Putting out general comments are basically
Okay.
not allowed, but we need to just
thank
give
you
a
for
direct question.
clarifying. Let me try to think of it as a question. Excuse me, sir, you're saying it incorrectly. Do you recall the trees being talked about being 20 feet tall?
Objection, ask and
That was a
answer.
question. What was wrong with
He's already,
that?
the question's been asked and he's answered it.
Okay, I think, ma'am, staff, I know the question be directed to him, but to clarify the issue, the evidence that's in file, what do we have exactly in the evidence?
According to the written decision from the planning board, under condition 3, buffering and fencing, the applicant shall install a privacy fence 6 feet extending to eastern end of berm on west side of subject property. Vegetative buffer shall be installed, trees or hedges as required by town staff to create buffer between applicant's property and adjoining homeowners.
Okay, so that's, I think that answers the question. And then you have another question you want to ask?
It's my turn to speak.
Okay.
Thank you,
Does
sir.
anybody else have a question, please?
Ms. Huber, hold on, just very quickly before you get
Yes.
in there, can you tell the mayor, you indicated your property address, but are you an adjoining property owner?
Yes,
just wanted
I
to clarify
am.
that. Okay.
Okay, ma'am, if you stand, identify yourself, please.
My name is Doreen Pearl. I'm at 1030 Golden Sands Way. And my property abuts. May I approach? I have this is an exhibit, I believe, was presented from the developers.
Well, ma'am,
Yes?
listen,
My question
I know
is-
what you're saying, but we need the question, and then
Yes.
we can identify what we need to do.
Was this presented by you to the planning committee?
It was not, no,
The height, to get the height
that was not presented in my presentation, no.
at all,
No.
by the developers at all?
It was not in my presentation, no.
Okay. Was it in anyone's presentation?
Would you mind telling us where you received that from, ma'am?
Yes, it was in the packet from the town of Belville.
I also received it, and I received it from Athena. And that's going to be my future question that I'll speak about. when it's my
My
turn.
town manager, we find out as yet, and,
That particular document, Mr. Mayor, was a document that was submitted by the applicant, and it was submitted prior to the hearing on November 30th. It was a public document. It was requested by some of the residents, and we provided that to the residents at their request.
Okay, so
It was
part of
not-
factual stuff.
It was not a piece of evidence that was entered.
Okay, so it's not a piece of evidence.
at that
This was
time.
not part of our application, and it was not a piece of evidence at the hearing.
It wasn't submitted in the, and by the way, I think it's marked as Exhibit G, is that right? A thing of the record from the prior evidence?
Yes.
So that's not been submitted into evidence?
Not part of the evidence, and it's not part of the special use plan. Permit. Yes, ma'am.
Was this used to get the height requirement from 35 feet to 40 feet?
I can't answer that. Since it's not introduced into evidence, we can't.
Objection is to further testimony about the document that's not in evidence.
The 40-foot height, by the way, just to clarify this, that's a zoning ordinance requirement, not a condition of the special use permit. I think the zoning ordinance has been amended at some point to allow for up to 40 feet, but that's not
I think this
it's not
is-
part of the application here. I think it's kind of a different.
But it's an impact of what a 40-foot building would
I-
impact the houses.
I understand. I think I
And it
understand
has
where
a
you're.
25-foot barrier between
I
Ma'am,
get where you're going, but he's answered the question on that. He didn't include it in his submission, which was his testimony.
okay, yes, sir.
So I have a question. So as a planning expert, do you feel that a 40-foot building and a 6-foot privacy fence in my property is sufficient to ensure privacy?
Sir, that is a hypothetical question, which is not relevant.
What's hypothetical? It's going to be 40 feet, my fence is 6 feet.
Sir, it's not, y'all can disagree. It's not part of what we're having this hearing about. Special use permit. I appreciate the questions, but I think we're getting to a point where we're not being relevant to what the facts that we have. We have to address the facts in this case. That's all I'm asking, just stick with that. Please. Any other questions? If there's no other questions, sir, thank you.
Thanks, Mayor.
Who's testifying next?
Mr. Mayor, we'd like to call our
Won't
next
be good
witness.
neighbors, I'll tell you that.
Sir?
Yes.
Yes, okay, sir,
We'd
go
like to call
ahead.
as our next witness, Mr. Elise Rocks. She testified as did Mr. Schuler at the November 30th hearing on behalf of the applicant. And she was qualified at that particular hearing as an expert in the field of appraising. I would again like to tender her as an expert to this board.
Yes, sir. Ma'am, if you would, if you identify yourself, give us a little bit of your background and then your testimony.
Yes, Mr. Mayor, my name is Elise Rocks. I'm a commercial real estate appraiser with J.C. Morgan Company. I've been working in the real estate industry in the region since 1999 and as an appraiser since 2006.
Okay. You want to go ahead with your testimony?
Yes, sir. I have did present evidence at the planning board meeting, and so just wanted to add to that. I have an update for you. I did in that evidence that I presented, I found my conclusion as an expert in the field of property valuation was that there was not any evidence to show a difference in property values adjacent to multifamily or adjacent to single family in comparable subdivisions and apartment complexes that I analyzed. There were some, based on concerns raised by citizens at the planning board meeting, I've also included a summary of my data that was requested that was specific to the Belville area. And while the data that I originally considered most comparable to the proposed project provides, I felt it was better evidence for you. I did want to provide this because it does provide support for my concluded opinion. I researched home sales in the arbors at Westgate and found that sales of homes that were rear adjacent to the single family homes when compared to homes that were adjacent to the Comet Westgate Apartments and the Summer Bay Villas townhomes. And based on the average adjusted price per square foot, the data indicates no negative impact on value for the properties located adjacent to the multifamily use. And I'd be happy to answer any questions you have about that.
Board members, any questions? Any questions from the audience? Yes, ma'am.
Hi, can I even get a copy of the convertibles that you have? May I get a copy of
The
them?
report's going to be offered into evidence.
And that'll be
And that's
okay.
Miss Huber, just for the record.
Oh, sorry,
Right.
thank you.
Yes, ma'am.
And what was the actual?
Yeah, it'll be presented to the council, yes.
Where do I get to see that? I don't know if I'll get a physical copy, or do I need to go on the website, or how will I?
Madam
get the
Town
website?
Manager, do we have that in our evidence?
Yes, we will enter that into evidence as Exhibit E.
Okay, anything we have in there, ma'am, you will be able to get us, once it's entered, being put down, we'll get that to you. Just
Physical paper, or should it be on the website?
This,
Yeah, we'll provide you with a hard copy.
Thank you, Tina.
Okay.
if you want me to summarize it, it looks like you just added, you did a study of home sales in the arbors at Westgate and compared the sales of homes rear adjacent to single-family homes were compared with homes rear adjacent to Comet Westgate Apartments and Summer Bay Villas, and found no material change in property values.
Okay, I'm gonna have to, and thank you for saying that, I just don't know where the Westgate Apartments are until I get home and look it up. I think they're by Walmart, aren't they? No.
That would be an appropriate question to ask, or where are those apartments?
It's located in Westgate subdivision, yes.
Where's that?
Yeah,
The back roads to Walmart.
The back roads to Walmart.
Yeah.
Nowhere
So-
near in the arbor though.
as I stated, the comparables that I used in the initial findings were more,
They were real.
it was a luxury single-family development alongside of a multifamily, which is why that was what I presented to the planning board. So it was requested, and this is a development that's in the market, and the homes are not as comparable perhaps to the ones that are in this study, which is why I did not cite them in my original testimony.
Okay, next question.
Again, my name's Doreen Pearl, 1030 Golden Sands Way, and in your expert opinion, having a building within 27 feet of my backyard, which this will be my view, will not affect the value of my home.
Ma'am, I understand what you're saying, that is not right now part of what we're discussing.
In our expert opinion, this will be the view of my backyard.
I know, go ahead and have a seat, ma'am. Next question.
It's outside of my scope, I don't know your house or
Yes,
have
ma'am.
enough information to answer.
Yes, ma'am, you go ahead.
I'm Nancy Freiberger. I live at 1100 Garden of Way, and our home backs up to the proposed development. I'm also a licensed real estate agent, and I've been in real estate for over 40 years. My question about the analysis that you did is how close were those homes, the apartments, footage-wise?
There's variations on, just like there will be here.
Let her answer the question.
There's variations and there's multiple levels, just like there will be here.
Do you have any idea of the footage between the properties that you compared?
It's a variation on all of these.
I'm afraid we're just spinning the wheel. She answered the question to the best of her ability. Do you have another question, ma'am?
I'm trying to figure out the single-family homes compared to the three-level apartments that we are comparing. Are we talking about, I'm not sure where they're located. Is it, do you have a map or anything that shows?
No, I'm sorry, I did not bring that information.
And if you would, if we have that in our file or packet, you can address that to our town staff, we'll
I
get
would
that
like
to
a
you.
copy of.
Okay, yes,
Mr. Mayor, if I can just provide some additional information.
Okay.
I think will help. Most of the buildings that are along the parking area, they're approximately 90 feet from the property line. And then there'll be some extra feet to obviously your house, you have your backyard and everything. There are some that are a little closer. Building 1 is probably 70 feet or so. And then building 11 is the closest building that's approximately 20 feet or so from the property line. And then there will be obviously your backyard.
okay, do we have another question? Yes, ma'am, please stand and recognize yourself.
Sharon Forsman, I live at 1131 Spring Glen Court. And if you're going down onto towards Aldi's, go around the roundabout, the arbors are this way. The apartments you're talking about are way over here.
Tom at Westgate.
Westgate, right. But that's a mile. That doesn't back up to the arbors. It's there.
Ma'am, that's out of order. Listen, let
I'm
people,
just trying to clarify.
I understand why you're trying to, but what we're trying to do here, if you ramble, are you not sticking to factual information that we have here? You got to understand, the board, listen, the board has considered this special use permit. That's the reason we want you to have an opportunity to ask the question, so we can understand. But if you're making general comments, it's hearsay. It's what you think. It has to be factual information. Factual. Yes, ma'am.
Sharon Forsman, 1131, she didn't give factual information.
Objection.
She didn't. The
Ma'am, you
arbors
have
are
asked
over
a
here.
question, ma'am.
Westgate,
I'm sorry.
I'm asking her a
It's an
question.
opinion. Go ahead and have a seat, ma'am.
No, I'm asking her how far
Ma'am, sit
Westgate is.
down. Okay, if you're asking a question,
I'm asking her,
okay.
The properties are adjacent.
but they're quite a ways apart.
The property line to the single-family homes that I analyzed are directly adjacent to the apartments that I analyzed. I didn't realize that was the question.
Okay. Are there any other questions from anybody? Yes, ma'am.
Hi, I'm Dorothy Pearl, 1030 Golden Sand, and I have a question for this gentleman, if that's okay.
She's had her opportunity to cross-examine.
But something else came up, so
Let's,
it's about, the 20 feet from my property line to this big building. Is there anything that can be done to help mitigate that? I'll have 12 apartments, clear view, but right into my backyard. What can be done to mitigate that? Yeah, it's a bad situation that we're in.
okay, ma'am. We'll take that in consideration. Okay, thank you. Do we have any other,
Yes, sir.
with the applicant?
Was her report entered into evidence, her supplemental report?
Are you moving it
Yes.
into evidence? Okay. Mr. Mayor, he's moved that into evidence. The supplemental report, he's asked to move that into evidence.
Okay,
The earlier report was already included in the
Yeah.
packet
yes.
earlier, and if I understood, just to rehash her testimony was that she felt like the earlier report had better comps, but at the prior hearing, some people had complained, well, those comps aren't in Leland. So she went and looked and found a comp in Leland, in the Leland-Belville area, to try to address that particular concern. Is that correct?
Yes.
Okay.
Okay,
But your testimony still is you felt like the comps that were admitted in the
Supported
original
my prior conclusion.
were more appropriate.
Yes.
Fair enough.
okay. Do we have anybody else that's testifying for that?
Just one more, Mr. Mayor, that at the original hearing in front of the planning board, we had Carolyn Cheeves as our traffic engineer with the firm of Ramey Kent. She appeared and gave testimony, which has been entered into the record, that Ms. Cheeves could not join us tonight, but I do have Rael Stevenson from Ramey Kent. He'd like to
Yes.
address the board.
If he's had relevant testimony as an expert, that'd be fine.
I was getting ready to say, if you're gonna testify about traffic, you're gonna need to tell the court there what you're.
Yeah, sir, we'll just use the name and his background.
Ronald Stevenson with Ramey Kemp Associates, 5808 Ferryman Place, Raleigh, North Carolina. I am a registered professional engineer in the state of North Carolina. I've been practicing traffic engineering, transportation planning for over 21 years. And Ms. Carolyn Cheeves did prepare this study, but I oversaw it and reviewed it. I'm her supervisor.
Okay, sir.
And so what I want to testify on this evening is traffic and the traffic impact from the project. We have prepared a traffic impact report, traffic impact analysis report that I will enter into evidence at the conclusion here of my presentation. But just want to take a few minutes to explain that to you all. So as I said, the purpose of the traffic impact analysis is to look at the traffic that would be generated by this particular site and development and look at its impacts on the surrounding roadways. When we prepared this study, we followed all the standards, guidelines, and practices and procedures of preparing these that are acceptable to the North Carolina Department of Transportation and the Wilmington Metropolitan Planning Organization and the surrounding communities in this area. So we followed all these practices in doing this. We took traffic counts at the surrounding intersections, and I'll tell you, our study area for this particular traffic study went down Pool Road and looked at Old Waterford Way, and then went down to 17 and looked at the intersections along 17 in this area. And these intersections would be the ones that would carry the bulk of the traffic from this particular development. So we took current traffic counts. We did the counts in November of last year, so we've got a little more normalized traffic patterns than we had during COVID. Took the traffic counts, we generated the trips and calculated the trips that would come from this development, added those trips onto the counts in the existing intersections, and then we prepared the analysis of the intersections to look at things like levels of service, seconds of delay at the intersections that would be as a result of the development of the traffic of the project. And what we found in looking at all these intersections is that the development itself would have a relatively minor impact, an insignificant impact on these intersections. The delays at these intersections that we looked at in the peak time, so the typical morning rush hour, the typical afternoon rush hour period, would be minimal. They were on the order of magnitude of 2 to 4 seconds, roughly, of change or increase in delay at the intersections. The one thing I do want to point out is that our study did consider that the NCDOT is looking at a improvement at Old Waterford Way. And if you're familiar with that intersection, there's a striped out area as you come out of Waterford onto 17, a striped out area that NCDOT is now going to basically convert to another right turn lane to come out of there. So we did consider that in our study as well. But as I said, the findings of the traffic study are that the development would have a very insignificant impact on traffic in the surrounding area. And I'll be glad to answer any questions.
Any questions from the board? Yes, sir.
I'm Jerry Pierce. I'm Vice President of the Waterford Master Residential Association.
Did your study look at the Pool Road's ability to carry the traffic that would be generated by this project?
Yes, sir, it did.
Did you make any recommendations to its improvements?
We looked at Pool Road, and what we looked at there were the driveway connections come out to Pool Road and the traffic that would be coming from there. And Pool Road as a two-lane road would be sufficient to carry the traffic that would be generated by the
Pool
project.
Road recently,
Yes, Pool Road,
and you're saying it could carry the traffic today?
the traffic study looks at basically capacity of the road in terms of number of lanes that it has and the lane configurations that it has. Pool Road does have some issues right now with, so, you know, those kinds of things will be worked out at a design stage, you know, of the
Would that be a
project.
recommendation of your study to make improvements so it could carry the traffic?
Those types of details of exactly how that is done will be handled through the, I think it was testified earlier, permitting, design plan and permitting stage. It'll have to be sufficient to carry, to carry traffic in a manner. And I know it does have some issues today, so
Okay.
I have certainly seen that.
Second question, in your traffic counting, did you determine that the peak traffic loading on those intersections was at 8 a.m. and 5 p.m. and not 12 and 1 o'clock or p.m.?
The standard practice for, and what we're trying to do with a traffic impact study is look at the highest impact of the development. So what hours of the day does it have the highest impact on traffic? So that for a residential project, that's typically the morning rush hour and the afternoon rush hour.
This is not a typical area, so when your traffic counts, didn't you determine that the peak traffic loading on Old Wolford Way was around the lunchtime hour instead of at 8 a.m. and 5 p.m.?
The peak impact of the project, of this development, is
What did your
morning and
traffic count
afternoon.
say?
Sir, don't let him
Yeah,
answer the question, and then if there's something else, then ask it, okay?
Yes, sir.
The peak impact of the development, which is the purpose of the traffic study, traffic impact study, the purpose of the study is to determine what's the impact of the development on the intersections. That peak impact of the development happens morning rush hour, afternoon rush hour. Will there be some traffic there during the day? Probably some. The highest traffic from the development is going to be in the morning and the afternoon.
But doesn't your study then assume that this is all working people and not retirees?
The traffic study, the way we generate the traffic from the development is we look at it is a multitude of similar sites that are compiled, and statistical analysis is done on those to say developments of this type, you know, which is basically apartment community developments, would generate X number of cars per unit, you know, per unit of the site. And that's what we base it on. And it's actually, there's so much data there that it's actually very accurate in terms of what it would predict for traffic.
I think in Raleigh it would. Around here, there's a lot of retirees and very little working people.
Objection, he's not qualified to give an opinion.
You don't know that I am not.
Sir, he got a legitimate
Okay.
objection. Now, you'll have your chance in a minute to come up here to
Yes, sir. I
testify after
understand.
they finish.
Thank you.
Thank you, sir. Yes, sir.
Yeah, I'm James Pearl, 1030 Golden Sands. How did your company come to hear about this survey or get this survey? Who employs you? Do you do this on your own?
I'm not sure exactly I understand.
Why are you doing this study?
We do the traffic study to determine what impact the development has on the surrounding roads, the public street system.
So who hired you?
We are employed by the applicant to do the study.
I just wanted to get that into record. Thank you. That's all.
Yeah, the study is done.
We don't need any more.
The study is done following national and local practices and procedures and methodologies. So we're not making up anything here. We're following standard practices with this.
So your profession, what you're telling us in your professional thing, it's not going to be a major impact on theirs.
That is correct. Yes, sir.
Ma'am?
Hi, I'm Doreen Pearl, 1030 Golden Sands. Do you know how many trips will be, once that development is in place? how many actual trips you can you calculate that will be made on Pool Road back and forth in a given day?
Yeah, definitely. And I can get you the exact number, but on Pool Road specifically, the development itself, when it's fully completed, would generate I think it's 2,200 trips a day. Okay, that's a whole day. In the peak times, as we were talking earlier, the peak times, I believe the highest hour of the day was 167 trips. I think that's the right number. So it's a little less than 3 trips a minute. And that's the highest hour of the day. We follow that question about Pool Road, I don't know if I can clearly answer that. We sent, to try to determine the highest impact, we sent the traffic down Pool Road, all the traffic down Pool Road, just to see how, as a conservative way to look at it, what impact could this have?
Okay, who else has a question? Ma'am?
Nancy Freiberger, Gentleman Garden Club. You have in your report how many trips there are at the intersection of 17 and Old Waterford, coming out of Waterford and going in?
Yes, ma'am, I do.
Do you know what that is?
If you're there, I'm not sure exactly what you're asking. You're asking how much traffic is there today, or how much the development's going to add to it?
Oh.
Okay. I'm going to read you the numbers so I get it exactly right. Today, coming out of Old Waterford Way, and this is just exiting from Old Waterford Way on to 17, we have the morning 356 cars in the morning hour, and then 768 in an hour in the afternoon. That's turning from Old Waterford on to 17.
So what is the total for the day?
The total for the day, I can give you an estimate for the total for the day, but we don't count the traffic for a 24-hour period on there, because we're looking at what the traffic study looks at is what's the highest hour of the day. So we're trying to look at the worst time, of the day, the very worst period of the day. So we don't take the current traffic counts for 24 hours to get a total daily traffic volume there. So the numbers I read you were the highest 1 hour periods during the morning and afternoon period, which is when the development would add the most traffic to it. If that makes sense. The highest impact of the development.
Okay, thank you, ma'am.
Well, I have a traffic study that was done in 2018 of that intersection.
Ma'am, would you state who the traffic study's from?
True Direction Traffic Services LLC.
Objection. She's not qualified to lay a basis or foundation for that, whatever that piece of paper she's holding.
Ma'am, he's correct on that. You have to, if it is factual evidence, it can be put in, but you have to be Noel, you want to explain that?
Yeah, I was going to say, two things. One, under a circumstance like that, you need to have somebody who had some part in bringing it if the other side objected. Now, had he not objected, I'd have sat right here and said nothing when you sought to get it in. Although thinking about it, the statute does say it has to be competent evidence from a traffic engineer. The other thing is, our focus here for the hearing is the impact about the traffic volume from the project. And I think I heard one of the questions someone asked was about the gross number of trips on this road during the day. But that's not as important for this hearing as the impact of this particular project at the peak hours. When you ask somebody what causes traffic problems, it's the peak hours of the day. Has been their testimony from the report that they gave. So you're trying to figure that out to see what practical impact that's going to have on the traffic in the area from that project. And I think if I've got your testimony right, what you're saying is you picked an hour in the morning that would be the worst traffic and an hour in the evening. And based on studies that are used in that field of study, those are the times you look at for residential multifamily places like this.
Yes, sir.
And I think Mr. Pierce, for example, was asking, the point you were trying to make, I believe, was that there may be some variance based on the nature of the thing.
The 5 p.m. is not up here.
And I don't want to make your, I don't want to do your testimony for you, but I was thinking that was the point it appeared that you were trying to get at. So I don't know that a traffic study dealing with gross volumes would really be helpful for addressing the issue that he's trying to establish with the board. But in this case, we wouldn't be able to let it in anyway without somebody to authenticate it.
I have one more question.
Sure.
In your report and your analysis, did you take into consideration other traffic that will be happening due to a new hotel that's going in the Waterford area?
$10 million.
Objection, that's all speculation. We don't know what's gonna happen.
It's already started being built. It's already under construction.
Okay, let's get back to, we're trying to be, wait just a minute, sir. I think our attorney can also quote me on this. When we get down, we're trying to hear everything that the opposition and the issues you have, because we want to hear that. But this is also a procedural deal, it's a quasi-judicial. It's based on strictly fact, hearsay, or what you think, or what you feel. If you have a competent, professional person that could take that paper and bring it up to us, that works for that company or can verify those facts, then it could be entered into evidence. But because it's not, it cannot be accepted as evidence.
And to narrow it down to that point that the mayor was getting at right there, but, and I'm going to use the worst hypothetical that you can think of. If somebody was building a new football stadium next to this, I don't know that that would really be competent for their permit, because we have to focus, again, we're confined to focusing on what the impact of this project is, not what somebody else's building was in this. Now, my recollection from the earlier testimony was that you built in some growth factor for projects,
Yes, we did.
in the future. But again, to go back to the specific one that you gave right there, I don't know that they necessarily had to do that, because the question that the board's stuck on for them is, tell us what impact this particular project is going to have on the traffic right here. Not what impact other people's driving habits, or what the building of the new Walmart or a new shopping center over there might have. That would be an appropriate question for the hotel if you were using that, if the hotel were applying to Leland for a permit, or even here. That'd be an appropriate question. Hey, what's the impact of this hotel? But unfortunately, these applicants have no control over that at all. And so it's really not an issue for them. It's not something that we can address in this hearing for them. And I realize people are concerned about a lot of those things, but we are really narrowly cabined in what we can consider here today. We have to focus on what this particular project is going to result in. And the other thing, I think we're hearing a lot of frustration about other impacts or just general ideas about it. Look, we're trying to judge compliance with building codes here too, with zoning codes. So things like the height of the building and stuff like that, if they're in compliance, they're in compliance. And if they're not in compliance, that's a legitimate thing to point out. But they are allowed to develop their property within those confines. So that's what the board's trying to sort out. Are they staying within those confines or not? So I hope that helps you a little bit. I realize that's not the answer that a lot of people want to hear about this. But that is kind of the question for the board. Are they moving within the confines of what the zoning ordinance allows there? And that's what we're trying to answer, what the board's trying to get to.
Yes, I hope we could. I think another lady had her hand up
Briefly,
first.
Mr. Mayor,
Yes,
briefly, real quick, and Mr. Blanchard, if I may.
go ahead.
I just want to remind everybody real quick that right now, the applicant is presenting evidence and testimony through experts, and this is your opportunity to cross-examine them on that evidence that they're presenting. At a later time, you're going to be able to give your own evidence and present testimony, and that's your chance to do that rather than question them. So anything that you want to present, you will have a chance to do that. That's just not at this time unless it is in the form of a question to cross-examine the testimony that's being given.
Okay, yes, sir.
Doesn't the DOT traffic impact analysis require you to include all known traffic impacts in your study? So if you know that a traffic impact analysis has been done before the one that you've done, like the one that was done for the hotel, it says they're going to generate X amount of trips.
Sir, let
Objection,
him
the
answer the
traffic impact
question.
analysis wasn't required.
Let him answer the first question you asked.
Now, I'm not sure exactly, but we do have to take into account traffic impacts. But we, as was pointed out earlier, we do allow for future traffic growth in the area, and we do that kind of uniformly, just because it's hard to predict exactly what's going to happen where and when. But so what we do is build in a growth factor for all the traffic out there. So it's not, even if something is submitted, the plans can change, or something changes later, or there's a rumor about something coming in. What we do is just take a uniform growth of all the traffic, out there, just to sort of be safe with that. But we do account for traffic growth in the area as part of our study, definitely.
Okay. We've got one more question, I think. Yes, go ahead.
Frank Smolak, 1119 Springland Court in Wilmington. So,
Hold on, Ms. Smollett.
I'm really, I guess my question is.
Ms. Smollett, hold on, can you explain where, are you an adjoining property owner, or?
I'm not an adjoining property owner.
Okay.
No, but I'm surrounding Waterford.
And you'll have a view.
Yeah.
You're down the street from it,
Okay.
you have a view of the apartments.
Okay,
Yes.
I'm not quite sure that's gonna be good enough for standing on this, if you just can see it from a distance. How far away are you?
It's not that far.
75 feet, would you say? Yeah, I don't know who determines what's considered far or close.
So you're not only adjoining a strip of properties, you're
No,
one
one-
right behind that?
Correct.
Now, just to be on the safe side, is there a particular question that's quick that you want to ask? So,
Well, it's kind of just moving
I'm still
forward.
rejected.
We're hearing expert testimony.
let's hear what she's got to say first, and that'll allow him to rule on the objection at that point. So what do you want to?
We're hearing expert testimony from experts that were hired by the applicant. What moving forward, because, we're just residents, and we have an attorney here who's objecting. So moving forward, what do we as residents need to do? Do we need to hire an attorney ourselves?
Okay, and I was going to say, under those
And that's
circumstances,
what
I'd agree that, Mr. Mayor, my advice to you would be that that's probably not a competent question for this. I will tell you, always a good idea to have an attorney on it, and when you're trying to offer, and again, I hope this will help us going forward, when you're trying to offer testimony about those two big things, property value, impact, and traffic, the General Assembly requires it to be from an expert. And that's why applicants typically come in with that, because they understand ahead of time that that's what's going on.
Okay.
So, yes, if that helps any, and I realize you didn't have much of a question for me.
And on addressing that, I think all towns, and even us, we're gonna try to put out relevant evidence. When you come before a quadrujudicial hearing like we have here, the legislative side, just as our attorney said, recommends that the people get competent experts or an attorney to represent them. So the evidence that's coming in, or what you're coming in, is relevant and factual on what we're supposed to hear. This type of hearing is not for hearsay, not for non-factual information on what might happen in the future. But I would strongly recommend, please study up on this. You have to get relevant experts, but I'm also recommending, and the legislative body recommends, get an attorney. Thank you.
Anybody else?
Any other?
Just like to make sure Mr. Stevenson's report's offered in evidence.
We'll mark that as evidence and expert.
Yes.
And Mr. Mayor, he attended him as an expert. Will you accept him as an
Yes.
expert in that field?
You are accepted as expert.
Thank you.
Do we have anybody else testify on behalf of the applicant?
Nothing further for the applicant at this time. We would like to reserve some time for rebuttal if necessary.
Yes, sir. If you'd like, we'll go ahead and get the opposition, and then we'll have time at the end of that for rebuttal. Now the opposition, anybody that'd like to come forth and testify, please come forward. State your name and your background.
Sure. My name is Jerry Pierce. I'm Vice President of the Waterford Master Residential Association. I'm a professional engineer in the state of North Carolina, state of South Carolina. I have over 40 years in local government, been Director of Engineering for the City of Rocky Mount, Public Utilities Director for Brunswick County, which you may have known me for that. North Myrtle Beach, Waycross, a lot of history of that.
Mr. Mayor, just to help for the record, what Mr. Pierce just explained to you about his role with the HOA qualifies as standing under the statute. So he doesn't have to necessarily live right behind it. He's qualified to his representative.
And we own property adjacent to it as well.
Well, that's good enough.
HOA owns property adjacent to it.
We're here to hear your testimony, sir.
Yes, sir. First, we sent you a letter, and I want to enter that into evidence. I think that you, in your legislative ability, to taking care of some of these, so I understand that. But one of the things you were just mentioning was about hiring an attorney, hiring experts. Under your ordinance, you get 10 days notice to do that. I don't think that's very realistic to expect that you're going to hire an attorney, hire experts like Ramey Kemp, who's a good firm, in 10 days. I don't believe that's realistic.
Sir, what I was recommending, this is not coming from the town, this is the legislative
Well,
body
I'm
of the
just
state of North
giving you,
Carolina.
your ordinance says 10 days, you're saying hire experts,
Sir,
that's not
I'm
practical.
stating North Carolina law that was put out by the legislative body of the state of North Carolina, not the town. I know what our town ordinance covers.
Yes, sir, I understand that. So, to further explain that, we got the last site plan 3 days ago, which didn't give us a chance to review the last site plan. So we didn't get 10 days notice, even though you sent out the notice 10 days, said everything, all the exhibits were available, they weren't, because they were only made available 3 days ago. So,
Mr. Pierce, you don't have to renotice it unless there's a material and substantial change to it. And this, I don't think that there have been any in this instance, but obviously you're here, so go ahead.
okay, we'll move on, because I think I've made my point about, you say hire an expert, hire attorneys, you don't give them time, the residents time to do that. So just, whether you as the town body or the
Sir,
town.
you're putting something into evidence that's not evidence. You're making a comment.
Okay.
This is an evidential hearing, we're here to hear.
The evidence is, you gave us 10 days, and that was not adequate time, that is evidence.
I'm gonna rule
Okay.
against you on that, that is not a factual comment.
Okay, moving on.
Yes, sir.
This is, I don't have a question for the town staff, I guess. Are there any other properties other than?
Sir,
He has
we're not here to
opportunity to
ask
ask
questions
questions.
right now. This is to put evidence into.
Okay. The BR zoning, business residential zoning, purpose and intent. The purpose of this district is shall be to provide innovative opportunities for integrating diverse and compatible uses into a single development. The business residential is intended to provide an alternative to the predominant development pattern characterized by unconnected, uncoordinated commercial development along thoroughfares and limited access residential developments isolated from places to work and shop. this is really a mixed-use development. This is not a mixed-use of the zoning district. This is not a mixed-use project. So I don't think it complies with the intent and purpose of the zoning district. I think the second point you may have taken care of by your ordinance amendment about the parking. Section 6.14 of the Belville zoning ordinance. I did not read where the town manager had the ability to waive that requirement. I don't believe they did.
What requirement?
The turn lane requirement. She does have a requirement?
That section of and I'm going by memory right here, but my recollection of it is 6.14, I believe the idea behind it, or the code provision says that if required by the DOT. Yes, as determined by the zoning code administrator or the DOT. So that there is no requirement for a turn lane or deceleration lane unless zoning code administrator or the DOT requires it, at least according to the way the code's written on it.
Mr. Mayor, the ordinance speaks for itself.
I mean, yeah, I was going to say that'd be my interpretation of it also, and unfortunately, I guess we're required to read it leniently because the law favors use of property.
And the zoning code administrator made a written statement that she did not require it.
Sir, right now, let's put everything into evidence.
Okay.
Let us hear the evidence that you have to present, and then we'll discuss
Okay,
it.
no problem. Okay. At least in the information that we got, a tree protection plan was not submitted. There may have been one submitted in the 2000, or in the, when it was just submitted 3 days ago, but the zoning ordinance requires a tree protection plan to be submitted. We've never seen one.
Objection. The ordinance speaks for itself, and the evidence has been entered speaks for itself as well.
Go ahead with the testimony, sir. We're not going to, right now, we're not going to answer.
I can
Got
say-
an objection, but,
The evidence is I have not seen a tree protection plan.
well, let's go ahead with your evidence. Let's hear it
Okay.
all. Right now, we're not going to answer questions.
Okay. Tax records indicate that this parcel is located, has a parcel located in the town of Leland. Based on my conversations with the town of Leland, they have not approved anything to this
Objection,
project.
hearsay.
What?
Hearsay.
I have talked to the town of Leland, and that's hearsay?
What the town of Leland told you was hearsay.
It's hearsay, sir. Not factual.
What they mean by hearsay is that the town of Leland has to come and testify to that. It can't be third party.
Okay.
That's hearsay, that's what the statute says.
They testified. Okay. Anyway. Well, have any of you ridden down Pool Road recently?
Yes, sir. I'm on Pool Road almost every day.
Okay. It is certainly in poor condition. I believe you would all agree with that.
Well, we're working on that issue, and I think it's going to be addressed along with this. It's something that we're working on.
Okay, but you don't have an agreement today for this developer to improve Pool Road.
Well,
Not a plan of, not any part of the plan I've seen.
In reality, his development got there. That road is owned by an entirely different person, the man that owns it. But that is being discussed, and the town is also having a discussion with the individual who owns the road. That is a private road.
Right, but although their plans that were submitted 3 days ago shows it's a public road. So I think it
Well,
would be.
any of them that goes in or anything that's listed where the general public goes is called PVA.
Well, I looked at the power bill map and it said private road, so.
Objection.
But you can get in, but anything that general traffic flows on during operational hours, according to the state, is considered a PVA. If, let's say if there's a gate or it's shut off, then it goes back to strictly a private, but a PVA can be a private road.
Right.
But it's as a general rule used by the public.
Right, but
That's the same way if you had a dirt road going to a garage that you run, in the state legal terms, it would be a PVA when it's in operation.
but the town of Belville's private, or Powellville map showed it as a private street.
Objection.
It is owned by private, but I think it's not something it's something we're looking at. We just address it that way.
Okay, and you don't think a condition would be appropriate to say who's going to approve the street? So,
Objection, we're wondering way outside the scope of the special use permit.
Yeah, we are, sir.
all right,
Thank you for, is that it, sir?
yes, sir, that is it.
Anybody have, sir, before you go, does anybody have any questions? Okay, thank you, sir. Who would like to testify next? Please come forward and identify yourself.
Good evening. Carol Huber, 1036 Golden Sands Way, Leland. Hi, Dana. This was drawn up, I'm going under assumptions maybe from your company. Please bear with me, it's a factual piece of paper in front of me that was drawn up sometime after the June, July
Objection.
hearings.
You've already plowed this ground with regard to
No,
materials.
you don't even know what my
and
question is going to be.
Ma'am,
Your question's
ma'am.
about that piece
I
of
have-
paper, that piece of paper is not relevant.
This
Right.
piece of paper
Ma'am.
has some information
Ma'am.
about
Ma'am.
landscaping and fences, and that's already been brought up.
Ma'am, you're out of order. There's an objection on the floor. What this is for, when you come forward, you have to give us testimony to fact. In other words, when you come up here to testify, if you have relevance, which you live to the adjoining property, so you get an opportunity to come up here and give us factual information so we can determine whether we're going to give the special use permit or not, make a judgment on it.
Okay, sir.
But it can't be how you feel or what you think. Nor do you want to address some of
Yeah,
that?
I was gonna try, I'm not quite sure, what is the relevance? How does this piece of paper bear on whether this application complies with the requirements or not? That's the thing I'm trying to sort out.
Thank you
How
for
it
asking.
potentially could be relevant. I mean, how,
Thank you. Thank you very much for asking. And this is from, I know it's my opinion, but I feel it's factual because we did talk about a fencing, the landscaping, that's been
Ma'am,
brought
you have,
up.
ma'am,
And I'm
ma'am,
answering
you
his
have
question.
to address it to the board.
okay, and yes, and it could
I'm
address
sorry.
the mayor. I'll listen in.
I'm
but-
assuming this is all the board, I'm sorry.
No, ma'am, it has to be
Okay.
addressed up. We're making a
On
decision.
this, we talked earlier about a 6-foot wood fence. In this rendition, it's an 8-foot fence
Objection.
with a 20-foot buffer on a 5-foot berm showing
Objection.
20-foot
Sorry, ladies and gentlemen,
trees.
That's
Ma'am.
not part of the application.
Okay, ma'am,
This
address.
is part of the landscaping question that our neighborhood has had.
Ma'am, I'm gonna have to stop you. For the simple reason, you have to understand, the testimony you give needs to be factual information. Where did that come from?
Your office.
Whatever, how is it
It
relevant?
came from the town of Belville.
Is
It
that
came
something that
from
we
this
put in the packet?
building.
It was a document that was presented to the town prior to
The reason.
the planning board's quasi-judicial
Well, it
hearing.
was prior to.
And it was
the planning
requested
board.
by the residents of Waterford Magnolia Green.
Correct.
And the town provided that to them because it
Yeah.
was a public document.
When you requested to go from 35 foot to 40 feet, this rendition was
Ma'am,
drawn.
you got,
And that's a different, remember, that's a different kind of the hearing for a zoning change
Okay.
is legislative. You're allowed to consider anything you want, essentially, in one of those. People can come and testify about how they feel about things and why it would be a good idea, why it wouldn't be a good idea. But now I understand where that came from. It's not, as I understand from the applicant, it wasn't submitted as part of their application. And that's the objection he's got here to it, is that this is not what we're proposing right now.
Okay, I understand.
I think
that
I hear
when
you
this
that you're
meeting-
saying it had been discussed earlier.
But why wasn't the residents of Waterford invited to that meeting when they requested going from 35 feet to 40 feet?
Okay,
Ma'am, you're out of
that's the zoning hearing that she's
That's
asking
still-
about.
Wasn't,
Ma'am,
we weren't
ma'am,
asked to.
Ma'am,
It was a public hearing.
you got to address the board.
Excuse
You
me,
gotta
I'm
stick to
sorry.
the facts. Right now, you're stating a motion, not facts.
I look at this piece of paper as fact. It has 8-foot
Well,
fence,
based on the
5-foot
testimony that's been
berm.
given, I'm making a ruling that's not relevant to this hearing.
The mayor's ruling is it's not being admitted, and it's the correct ruling here because it's not, it hasn't been submitted as part of the application, just to make it clear, and it didn't make it into their application. I don't know why. That's their choice to put in the application what they want to put in the application, but it's not there.
That should have been considered though when they came up with the idea of what you're going to do for the landscape for our residents. A 6-foot fence is not going to.
Ma'am,
This
ma'am,
is my
please.
view from my dining
Ma'am.
room.
Ma'am,
That's what I will have. Thank you.
That's,
Excuse me?
uh,
What?
No, I was being sarcastic.
Okay, I'm sorry.
ma'am, please.
Yes. What?
Hmm? Thank you for your testimony.
Thank you for not hearing
Ma'am,
Waterford.
sit down, please.
Okay? We're done.
Is there anybody else that wants to give testimony? Yes, ma'am.
I do not live in the affected area,
Okay,
but
ma'am.
I have,
All right.
it's not about evolve,
No, ma'am.
it's about the procedure.
Have a seat, ma'am.
please, yes, not,
You're not
don't
wrong.
have standing on this one if you don't have a property right there.
It's not about procedure, not about evolve.
Ma'am, that's enough.
That's going to be my dining room view. Please submit that.
Objection.
No, I'll object my ass.
Is there anybody else that would like to testify?
That's a question, but there's no question, so.
No, ma'am, right now, we're collecting evidence. We'll get into a rebuttal coming up. If anybody would like, on the opposition side, have a rebuttal, then you can make some comments. Is there anybody else on the opposition that would like to make any factual comments to give to the board? If not, I think we're finished with all the categories now. If we do have any, I will go, sir, if you want to do a rebuttal.
The applicant doesn't have a rebuttal on it.
Okay, you don't, you fine, sir?
And Mayor, it may help to ask if there's any further questions. I think you had indicated so when they get an opportunity to question the staff or the other folks. I don't know that there will be any, but
Okay,
just
any
be on the safe
questions?
side.
Yes, ma'am.
How are
Yes.
you? My name is
Stand.
Lisette Berrios. I just have a general question. Everybody's welcome to Bill. I have a question. How did you come up with the name for Evolve?
So, ma'am, that's not relevant, has nothing to do with this.
Because they included Waterford instead of Belville.
Okay, you're out of order. Sit down, ma'am. You're out of order.
That's a valid point though,
No, ma'am.
because
it's not.
Waterford is in
No,
Lincoln,
no, it's
not
not,
in
ma'am.
Belville.
Ma'am, I'll have you escorted off the property,
Oh, I'm leaving because we're done.
please. I asked everybody, please, to be civil. Let's get through this process. We want to hear everybody. But there's no reason to holler and scream. We want to hear the evidence. Is there anybody else that would like to make a comment? We'd love to have you to go ahead and make it. Okay, thank everyone. Okay, at this time, what we have to do, and Noah, if you would, I think since all the evidence is in, there's no rebuttals. We've heard from everyone and the information and commissioners. I think this time, if there's any questions from y'all or anything that you want to ask of any of the participants.
And for what it's worth, Mayor, I'd like to point out again that Exhibit D in this was moved in by the applicant, I think, which was their testimony and cross from the prior matter. That is sworn, it's competent evidence, it's admissible for that reason, the fact that it was under oath. Once the applicant makes their initial showing on all the elements, again, it's the board's duty. You can't impose reasonable conditions, but we are obligated, if you conclude that they've made that showing, to grant the permit. Again, you can impose reasonable conditions, but if they make the showing on all the elements, then you're obligated to move in that direction.
Yes, sir, and I think, in our decision, the variance as far as the parking is also part of this package and part of our hearing.
Correct.
Which will be part of our conclusion if we accept this and approve the permit. We do have I got it, now I moved everything around, so I got to find it.
You have a worksheet that'll move you through in a coherent fashion now.
We have a worksheet, and the way this will work, so you know the process. The Board of Commissioners will go through this. There's a sheet with all the criteria on it that we will have to answer. And based on that, it'll be a motion request to ask whether we approve or not approve the special permit. And at this time, if y'all will, look over this. And like I say, if you have any comments, you give us just a few minutes to work through this worksheet.
Okay.
Oh, they put their names in their hands. Doesn't really have any, except this one guy.
Yeah, if the board members have finished the worksheets, you can pass them up to me. Oh, we'll take those. Last question.
Mayor, just to clarify, you're not bound by the planning board's conditions if you do decide to grant this or not. You're not bound by their, you can modify those. But it is important that we address, as you pointed out, the request to modify the parking. One way or another.
Give my board members a few more minutes to finish the calculation.
I didn't leave the door open.
Any issue within the check sheet that the board members that y'all want to discuss or any comments on?
I would just recommend that under number 2, that we include the conditions from the planning board.
Yeah, what we have to do is the variance for the parking that will be considered as well as basically I think the applicant we're looking at already give us this copy of issues that come from the planning board, and we can either put that in as the variance, and the condition is if y'all so vote that way, we're just talking about the ones that y'all have already looked at as far as things y'all will try to do to compensate some of the issues from the opponents of what's going on. Which I think y'all have addressed, from based on this, they've been addressed. Do y'all have any questions, or let me know when you finalize, and then we'll go ahead with the motion. Ruling. And we finish, I'll need your worksheets if you don't mind. time turn, if you would, I think they also need to put it in that they realize the vote of the board, it has to be 4/5 of the ones present
For the variance only,
for the variance only.
for the variance part only. This, the other part, the condition, the special use permit, again, was just recently changed by the General Assembly, so it's a pure majority. But to lower the parking, it has to be 4/5 of the ones present, you're correct.
Correct.
Which in this case would effectively mean all 4 of you.
Just to double check that, so are we going through with the minor modification or variance?
The minor mod, and I'm trying to think, do you treat that as a variance or do you treat that as a pure administrative adjustment to the SUP?
Not a variance.
Okay, do you treat it as a pure, well, I stand corrected, you're right then. It's part and parcel of the SUP. You can excuse that if you wish to do so as part of the.
No, we don't have to consider that in our decision making.
Now that you mentioned that, that was your idea in changing the.
Right, minor adjustments.
So it's a minor adjustment which not has to fit into this hearing.
It doesn't have to be a 4/5 vote, it's a simple majority. Right?
Y'all are gonna have to make a decision
Yes.
on that issue, but it's outside of the.
Well, we'll vote on it tonight.
You know, the reason we had changed that just was that to make a minor modification was to allow people a little bit of leeway on some conditions, but this was one of the carve-outs that the town manager could not do, right?
For special uses.
Because it was a special use, it has to go to the board instead of being administratively done by the manager. We just changed that last month, so I'm not real familiar with it either, other than.
Commissioners, let me know when you finish. Thanks, sir. Any comments from the board members before we put out our decision? No comments? Based on the board hearing all the facts of what's happened, and based on that decision, based on the following findings of fact and conclusions, that decision of the board that the applicant for a special use permit be granted subject to the following conditions, which I think you already know what the, was the one that was already approved by the planning board. It's on this sheet here. Do y'all have anything on that? Now, I think, since we granted a special use permit, that we have to do separate for the
minor adjustment.
Minor adjustment on that.
Separate
So
decision.
if there's not an issue, can I have a motion that we accept that change?
I make a motion.
All in favor? All opposed? The ayes have it. I think is that all the business that we have to conduct on this board tonight? Any
So,
other issues or
just to make it-
anything we need to address?
Mr. Mayor, to make it clear for the clerk over there, you're adopting the proposed conditions that came from the planning board. Is that correct?
Correct.
And,
We're accepting the facts have been presented here today, and the factual information that was addressed by the planning board, and looking at their recommendation.
that's
on
it.
what they did.
The conditions were the one that would, because they're gonna have to sign off
Yeah.
on the conditions as part of the permitting process now. And you represent, you'll accept those? Okay. And, just so, that, again, that the clerk can get this clear, did all 4 of you find on all of all you would need is a bare majority, but on all 9 topics, all 4 of you found in favor of the applicant on those?
Yes.
Yes, okay. Good, that makes our record good and clear on that.
Yes.
Okay, and Mayor, if I'm hearing you, you adopt the facts from the planning board.
We adopt the facts from the planning board hearing. They're in the record, and like I say, based on the opinion from the board, the application of special permit, granted.
We'll prepare a written
Yes.
finding for that. It has to be in writing, that's when your time and any other party. And I've got 1, 2, 3, 4, 5, 6, 7 other folks who would have, potentially could appeal it if they want to, but your time runs from the time that's served out. So.
Is there any other thing that we need to put out? Any comment from staff?
No, Mr. Mayor. Thank you.
Okay, Mr. Norwood, is that it for you also?
I believe that's it.
Okay, another thing, the only thing I have, can I have a motion that we adjourn?
So moved.
All in favor?
Aye.
All opposed, ayes have it.